Hi, I'm Timothy Morris. I'm an attorney in Harnett County. In my 25-year career, I've helped numerous people who've been involved with serious automobile wreck cases, and I can help you too. Let's look at what happens when you've been involved in an automobile accident that's not your fault. Number one is the at-fault driver is going to contact their insurance carrier, and that carrier is going to begin immediately preparing evidence to defend any potential claims that may arise. Now let me ask you, do you think that they're preparing evidence that will help any person against their driver? And of course the answer is no. Let me explain in real world how this may go down. You get a phone call, again, while you may be at home recovering from your injuries, you may be in pain, who knows. But this person will be pleasant enough and they'll exchange pleasantries like, how are you doing? And your initial response may be, oh, I'm doing fine, in spite of the fact that you're in some pain and or recovering. They may ask you about what happened during the accident and ask you, let's say, how fast you were going. Well, again, you might be in pain, you might be on pain medicine, who knows. But if you answer, I was going over the speed limit, and you don't really know the answer to the question for sure, it becomes important to know how that could affect your case. Number one, keep in mind, because you're saying it, it's going to be admissible in court. So if you take a witness stand and you're describing injuries that you have and pain that you've suffered, that statement's going to come back because someone's going to say, well, we called him and he told us he was doing fine. Now, more importantly, on the question of the speed limit, in North Carolina, we're a contributory negligence state. That means that if you're 1% negligent, you're entitled to no recovery. And going over the speed limit and speeding could potentially be something that would take your case, which would have some value to it, and render it absolutely valueless. Could destroy your case. So you may be asking, what should you do in that case? Well, number one is just don't talk with them. Tell them that you would like the benefit of having spoken with an attorney prior to the time that you give them any statement. And I can assure you that any attorney that knows what they're doing will tell you, do not talk with the insurance companies. Number two is, and this is more of a reflection of, I guess, modern day society, is don't post anything on social media. I can give you an example of that. I had a client that was involved in a very devastating accident where he was injured, but he survived. His mother posted a photo of the car and said, thank God that her son was okay. Okay to her meant that given the severity of the accident, that he survived. Well, when he came to speak with me, he could hardly breathe and he had a broken clavicle, dislocated collarbone, and I think some broken ribs. So okay to her might come back to haunt him in a particular trial where he's alleging different levels of pain. So the best advice is just don't post anything on social media. Rule number two, get better. Do what your healthcare providers and or your doctor tells you to do. Don't miss any of their appointments. And it may be common sense, but there's a reason for that, is the insurance companies are not going to know anything about you, and they're certainly not going to take your word on the level of pain or what damage that you may have unless it's documented through medical records. The same way or the same idea applies to lost wages. A lot of people will go to work when they have no business going to work, when they're in a lot of pain, but the insurance company's not going to give you credit for being the kind of person that plays through that pain. They don't know you, and I don't fault the insurance companies for this. They don't know you, so they're going to assume that if you're able to go to work, you must not be hurt. And the final reason is not only will you be getting better and doing what they're telling you to do, the law allows recovery for medical bills and lost wages. As to lost wages, as long as you can document that with doctor's notes, the insurance companies rarely fuss over that. I'd like to say that they don't fuss over medical bills, but within the last year or so, they've gotten terrible about wanting to pay you for all of your reasonable medical bills. But those are two items that are recoverable under North Carolina law. One of the first questions any client asks me about their case is, what is the value of my case? And the short answer to that is no one's going to be able to give you a definitive answer about the precise value to be placed on that case. However, I would say this, that if you're not hurt, your value of the case is just what it should be, and that is nothing. I can tell you, though, that what the law in North Carolina allows in terms of recovery. Number one is lost wages, and that's ordinarily pretty easy to document. You get someone from your work to state how many hours you missed of work and what your hourly wage is. Also, typically you can recover your medical bills, and again, that's an easy matter, and it's part of why you would get an attorney for us to gather those records for you. If you have any scarring, that's kind of an imprecise formula, but obviously a scar behind your knee is going to be valued less than, say, a scar on your face. So the final category is one that really is what ends up being very difficult to prove, and that's an area or a category called pain and suffering. And pain and suffering is not something you can do a scientific formula for. I can kind of give you an example though. If you have an x-ray, you're going to have a medical bill, but typically an x-ray may not hurt. The x-ray may cost $300. However, in terms of assessing the value is going to be different than, say, if it only costs $200, but they had to push the bone back in your skin. One of them just hurts more, and one of them is going to be something that a jury can relate to. I say that to say this: you have to document those injuries. You can document them through pictures. You can take statements from your friends to give you an idea as to the level of discomfort that you've been in. The medical records themselves also offer some documentation. And there are times when I ask my clients to keep up with a diary, because the pain that you're going through at that time oftentimes is very difficult to go back and reflect on. I can give you one more example about that. I've had clients that have had broken ribs, and for 6 to 8 weeks it hurts like anything to get out of their bed. Well, in front of a jury, they may have that diary to say, on this day I could hardly get out of the bed, and it makes them remember how difficult it was and for that length of time, rather than merely looking at a jury and saying, yeah, it hurt when I got up in the mornings. Let me explain to you the process. You'll call my office and schedule an appointment. Now, we recommend that you get in to speak with me as soon as you're physically able to after the accident. In fact, talking with me real quickly is so important that there are times when I'll go talk with you at your home or even at the hospital. Remember that the insurance company has already started their investigation, so they're a leg up on you. It also allows me to give you advice like don't talk with the insurance companies to prevent the harms that we spoke about earlier. For example, I'll tell you don't talk with the insurance companies and don't post anything on social media. I'll also have an opportunity to go to the place where the accident occurred and take pictures and investigate that myself, so that I can see, for example, where glass may be situated in the highway, which can later be extremely important to establish where in the roadway the accident occurred. After I have had an opportunity to investigate the case, and this is regardless of the extent of the injuries that you have, I'll give you an honest opinion about the value of your case. And that'll be, we'll look at the strengths and weaknesses. And I can say that some of the best lawyering I've done is sitting across the table from somebody, even people that I greatly admire and like, and telling them that they just don't have a case. If I determine that you have a case, I'll have you sign a fee agreement. Typically, that is a contingency agreement, meaning contingent upon me getting a recovery before I am entitled to any fee. After you sign the fee agreement, I'll have you sign some medical releases, which will allow me to gather your medical records. The fee agreement allows me to put the insurance company on notice that I'm your attorney and to tell them not to contact you anymore. Then I begin an investigation immediately. And part of that is to document things through taking pictures. I'll oftentimes personally go to the scene of an accident, take pictures of the scene. I'll take pictures of the car. I'll take pictures of the injuries if they're visible or if it's at a time that I can take those pictures. I'll gather the accident report. From that accident report, I can determine what witnesses, if any, were there at the time of the accident and identify them to perhaps interview them. I'll contact the emergency medical workers when I determine who they are and see what, if anything, they recall. And of course, I can also talk with law enforcement officers. Then, after I'm in the process of gathering that information for you and preparing your case, I'll remain in touch with you to find out how your recovery's going, to find out potential other witnesses, to find out availability when you may be able to ride out to the scene of the accident and describe what happened. But your primary job at this point is to let me do my job and you just get better. At some point, you will stop your medical treatment. Hopefully, at that point, you'll be better. But sometimes you've simply reached maximum medical improvement. Now, at that time, I'll bring you into the office and we'll discuss your case and we'll discuss the demand that we're going to make upon the insurance company. We will prepare what's called a settlement package, and in that we include those things that we've gathered, like pictures of the scene, pictures of the injury, the accident report, the medical bills, the EMT reports, and all of that information that will give the insurance company an idea as to what the value of the case is. We will then demand an amount for settlement, and we'll make it clear to the insurance company that if they're not willing to settle the case, then we're willing to take the case to court. And I can say that it's extremely important that an attorney be willing to prepare that case, to take that case to court. Otherwise, during the negotiating phase, the insurance company is simply not going to take you seriously and not value that case in the same way that they would with an attorney that they know means business. Let me conclude by saying that car wrecks leave a lot of carnage, literally and figuratively. You oftentimes will miss work. You'll have doctor's appointments and medical bills that arise. You'll be restricted in what you're able to do. You'll have pain. Hopefully you'll get better, but there are times when you're going to have pain in some variety for the rest of your life. And in extreme circumstances, you may even have lost a loved one. I hope that's not the case. I have represented families that have lost loved ones, including one particular family that I'll always remember, who lost 3 members in one accident, which involved a transfer truck. And the last thing that family needed was for an insurance company to be jerking them around during that terrible time in their lives. You need an experienced attorney that'll help guide you, that'll take the helm, guide you through this process, answer the questions that you may have. I'm Tim Morris, and I can help you with your case.